Hi, I'm Barb Culver, and I'm president of Resonate Inc. Thanks for joining me today for this brief YouTube presentation on the estate planning mistakes of the rich and famous. No, I'm not an attorney, and I'm not trying to provide any legal advice in this presentation. I'm simply providing examples that are available in the public domain, which I'm offering to you today in an educational format. I've been reading about estate planning failures of the rich and famous for years. Stories are readily available on the internet, and I also referenced the May 2013 issue of the Insurance Newsnet magazine to gain some examples for today's presentation. The thing that interests me is that the mistakes seem to be repeated year after year. And while the authors of these articles use examples of the rich and famous to help attract attention, the errors that are publicized can be made or corrected by anyone. So, in our ongoing attempt to provide useful information to you, let's wander around the estates of some of the rich and famous to see what not to do in our own planning. Do you remember George Jefferson from the Jeffersons? Well, George's real name is Sherman Helmsley. And in 2012, he died from lung cancer at the age of 74. Even though Sherman is included in an article on the rich and famous, this story might be more aptly termed simply the famous. This is because when he died, even though people naturally assumed he had money, Helmsley died with only $50,000 in his estate. For decades, no one in Sherman's family had come to visit, nor did he talk about them, even with his beloved partner of many years, whose name was Flora Enshinton. That is, nobody talked about the family or showed up until Sherman died. Soon after his death, Helmsley's half-brother, Richard Thornton, showed up from Philadelphia to contest the will. You see, Helmsley was living in El Paso, Texas, and had been there for some years. He wanted to be buried there with military honors that he received while he served in the Air Force. Thornton, on the other hand, wanted to take his brother's body back from El Paso to native Philadelphia. Of course, Thornton also wanted to receive the financial value of the entire estate. For 3.5 months, Helmsley's body was kept in a refrigerator while the will was contested. The reason that Thornton was allowed to contest the will includes the fact that Helmsley did not sign the will until 6 weeks before his death, even though he'd been dying from lung cancer for a much longer period of time. So, this opened up the possibility that either Helmsley might have signed the will under undue pressure, or because of the drugs he was taking for the lung cancer, that he might not have been totally competent when he signed his will. And the other reason that Thornton was allowed to contest is although he was only a half-brother, the DNA test proved that he was a blood relative to Helmsley. In the end, Helmsley's burial wishes were followed, but the estate continues to be contested through February 13th of this year, 2 years after his death. So, what lessons can we learn from George Jefferson? Number 1, be sure to create a new will if you move into a different state as quickly as you possibly can. And whether or not you're moving, if you do not have a will, please get one written and signed as quickly as possible. Finally, you might want to consider a no contest clause in either your will or your revocable living trust. These, of course, are matters to discuss with an attorney. A second example involves someone that I'm sure you've also heard of. From baseball's Hall of Fame, we next talk about Ted Williams. Ted Williams was 82 years old when he died in 2002. Now, in this case, Ted Williams had a will that was written all the way back in 1996. And in it he said, "I direct that my remains be cremated, and my ashes sprinkled at sea off the coast of Florida where the water is very deep," unquote. However, immediately after Williams' death, two of his children, John Henry and Claudia, produced a handwritten note that was supposedly signed by Ted Williams himself. The note said that he wanted to be cryogenically frozen. Over the protests of their sibling Barbara, who said her siblings were violating her father's wishes in his will, within hours of his death, John Henry and Claudia whisked Ted Williams' body away to Arizona. There, his head was removed and placed in one container while his body was stored in another. Incidentally, at that time, this procedure cost $120,000. Now, the odd thing about the note is that it was signed Ted Williams, which was a signature typically reserved only for autographs. Normally, when signing legal documents, like all of us, Ted Williams used his full name, Theodore S., for Samuel Williams. Now, part of the additional problem in this case is that Ted Williams had disinherited his daughter Barbara, who was contesting what her siblings wanted to do, when he wrote his 1996 will. Nonetheless, she continued to fight her siblings. Legal fees, of course, were rapidly depleting the estate, and eventually the siblings settled on receiving accelerated payments from a trust that was worth $600,000, which was to have been split among the heirs. So, lessons to learn from Ted Williams are that, at least under Florida law, and I know that many clients do go to Florida to live out their later years, the authorities may consider how a person wishes for his or her remains to be disposed of, but they usually let the survivors decide. In this case, John Henry and Claudia attempted to establish that they, not their half-sister who had been disinherited, they were the children that their father relied on, and they should decide what to do with his remains, and the court approved. In addition, we can also learn that if you do decide to leave someone out of your will for one particular reason or another, it's important to let people know exactly what you've done and why. Complete secrecy breeds contempt. Keeping your loved ones informed eliminates big surprises and oftentimes lawsuits. You can also write a letter, which is to be read after your death, which explains why you chose to include the provisions you did in your will. Again, please be sure to consult with an estate planning attorney, especially if there is significant tension within your family. In addition to creating your will, you might also consider creating a trust, which is less easy to contest than a will. You know, in spite of everything that we know today, there are still about 70% of Americans who die without a will. And we want to be sure that everyone who listens to this YouTube presentation, all of our clients, your friends, your family, your associates, are aware that you do need to have a will. You need to keep that will updated. You need to keep it current if you move from one state or another. Otherwise, there may be trouble lurking beneath the surface. And the way that we can help is that we make sure all of your financial assets are coordinated with your legal documents. We make sure that titling and beneficiary designations match what you want to have happen in terms of the transfer of your estates. So there's a vital partnership between your financial advisors and your estate planning and legal team. One of the best ways that you can say, I love you, for the final time, is to be sure that you do not leave your loved ones any type of a mess, legal, financial, emotional, or psychological. We're here to support you in completing this important process. Thank you again for joining me today.